that purpose. Also, and I apologize, I forgot to bring this to the people's attention ahead of time. I did want to address one of the bond conditions, if the court will allow.
Trying to surprise Mr. Cook? No, it's okay. It's okay. Just well with that.
I think he can handle it, but I'm not trying to surprise him.
Go ahead.
Oh, it's pertaining to her, the Sober Link. It's a cost issue for her, and so we are requesting random alcohol testing instead, random ETG alcohol testing instead.
Well, if I had random ETG, she'd have to take one every week randomly. And I'm not clear that her cost, I don't know what the difference in cost would be.
Oh, I understand what you're saying. I think the Sober Link is $6 a day. Is that right?
Yeah. I think to
well, no. How much an ETG test is, if there had to be a confirmation on it. Let's do this. So how much time did you need?
Would 2 weeks be agreeable with the court and the people?
That's fine with me.
Thank you, Your Honor.
Public cause conference will be adjourned to March 26, 2026 at 9. Bond will continue. Mr. Cook, are you going to have a position on that?
I would ask if the court does do the random testing be at least twice a week. My reason for asking that is the BAC, from my recollection, is 0.166. I believe there was a crash, and the defendant didn't discharge the firearm during that crash. So I think there's serious safety concerns as it relates to alcohol, and having that bit of a closer look at the defendant's sobriety and oversight would be a good idea.
So you're suggesting no change?
No change, or the court's going to do random testing at least twice a week.
Twice, 2 times a week. All right.
Your Honor, if I may, I'm not disagreeing with the allegations as reported by Mr. Cook. However, I would note that thus far, she's been compliant with the Sober Link. There have been no issues. Prior to this incident, she's had no previous issues with alcohol, and she has no drug history at all.
Okay. What I will do with reference to that is momentarily before you leave, what do we have it?
So it's $15 for the initial test, and then the confirmation test, and we just $30.
Now things get serious. The prosecutor brings up a .166 blood alcohol level and a crash involving a firearm details. That immediately changed the tone of the conversation. Even if the defendant has been compliant so far, the judge has to balance fairness with safety. That's why you'll often see judges hesitate before relaxing bond conditions in cases involving alcohol and potential danger.
So $6 a day, 42 a week. But to do, and I could think defer to the people. So she did 2 ETGs, gonna be doing 30 a week. Savings of $12. Unless one comes back positive, which she would likely want to have a confirmation test, which is then going to cost her 30.
Confirmation.
oh, we'll come back to that. So there's a matter.
Okay, I see.
Do you want to switch to that?
I think so, yeah.
I'll tell you what I'm going to do. I'm not going to make a change at this point. You're coming back in 2 weeks. Look at it, and then I will make a decision.
Okay.
26.
Thank
Okay.
you, Judge. We appreciate the consideration and the information from your staff.
Thank you. I was expecting to see him on.
Introduce yourself. Jeremy Shue.
I know Mr. Shue.
Thank you.
Had our moment. All right.
Denied the Zoom hearing.
Yeah, all good and getting better, Your Honor. No, Mr. Shue is here in person. I wanted to ask the court to consider a motion to stay. We're in the same holding pattern that we have been. He has a pro per interlocutory appeal on a companion case, and that companion case involves the same series of episodes and the same car stop that is the subject of his interlocutory appeal. Last time we were here, Your Honor continued it rather than staying it just to see what would continue to happen in the Court of Appeals. What has happened is they dismissed on administrative grounds. Mr. Hsu filed a successful motion for reconsideration. They've now, because it was just an administrative dismissal, it never got to the merits. They've now reopened it, and it's continues to be on a leave application.
Okay.
And rather than come back every few weeks, we're asking the.
So I guess I'm a bit confused. I'm a bit, I won't say confused, but want to make sure I have an understanding of how the decision in that appeal affects this case.
Sure. So there are a series of alleged episodes that took place in a neighborhood, some items that were allegedly taken. And the first case is a misdemeanor case in Judge Washington's courtroom involving the first set of items that were potentially recovered in a car stop, or at least items that might look like those items. This arrest came many months later, involving another house in that same neighborhood in that same period of time, and also involving things that were found in that car stop. So if that is a bad car stop, then that impacts this case as well.
I see. So it's really, I see what you're saying. Do the people have a position?
We'll leave it up to discretion of the court.
On
I would leave it up to discretion of the court on objection.
here, so my other issue with granting a stay, which is, I mean, I get why you would want that to happen, but are you asking, in essence, for an order similar to that was signed by Judge Washington?
That's right, an identical order, and I'll keep the court up to speed as things develop in the Court of Appeals.
All right.
She set a status date for a few weeks from now.
Status date for March 26th, but I wouldn't do that. And how, I'm just thinking timing wise, I'm not sure how fast or slow the Court of Appeals is operating at this point.
Yeah, I mean, I have to be honest, I'm really surprised that it's taken this long, but and I may have been because of the initial administrative denial, but it doesn't seem to be moving anytime soon on this.
All right, what I'll do is I'll order it stayed with the next court date being, I'll just go a month out from there, April 23rd. (2026) for status. And then I'll just adjourn. Well, the way we'll have to do it here, since it's not my misdemeanor or my district court docket, technically, is I'll have to give the probable cause conference that date. Okay. Effectively kind of a stay, but.
No, that works, Your Honor, and I'll be in touch with your staff and with Assistant Prosecutor Childers as their developments, and in advance of that date, if it's still in limbo.
Yeah, if it's still in limbo, and so that I'll state this on the record, my staff will remember this. If we still don't have a resolution, now that I can appreciate what you're saying in terms of the case itself, I'm not going to have a problem adjourning it by stipulation.
Okay.
Say a month out, so we'll just see where we are.
Great. Thank you, Your Honor.
All right, thank you.
Next time.
Please state your name for the record, Joe. Joseph Smith.
All right. Think I may have a plea form,
Correct, Your Honor.
and that would dismiss that one. Okay. So the plea form indicates that he's going to plead to count 2 of use of a controlled substance, that being cocaine, the 1-year offense. Upon a successful plea to that charge, or count 2, count 1 would be dismissed. And so I'm also clear, this is taking place in the case 1915.
Correct.
And then upon a successful plea in that, to that count 2 in that case, count 1 would be dismissed in that case, as well as there would be a dismissal of 25 FB 1343 FY. And that is the entirety of the court's understanding.
Yeah, I believe we're going to file a nolo. Go ahead.
Yeah, I would file a knowledge on the source. It's on entry the plea will go by wireless.
Okay.
But yeah, that's what we're doing today.
All right. May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Joseph Smith.
All right, Mr. Smith, it's this court's understanding that you're going to plead guilty to the charge of use of cocaine. Is that your understanding?
Yes, yes.
That's a misdemeanor, punishable by up to 1 year, $2,000 fine plus court costs. You understand that, sir?
Yes,
All right. And understanding that, you still wish to plead guilty,
I
right?
do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes.
Any question regarding any of those rights?
No,
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
yes.
Were you on probation or parole at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No,
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
I am.
And because you believe that you're guilty of this offense?
No.
This is the critical moment of the plea hearing. The judge isn't just asking questions casually, he's building the legal record. For a guilty plea to be accepted, the defendant must clearly admit the elements of the crime. That's why the judge asks directly, did you possess it? Did you use it? Once those answers are on record, the court can legally accept the plea and move forward to sentencing.
201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes,
Had you used it?
yes,
Did you know what you were using was cocaine?
I did.
Okay. Sir, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
I do understand it.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
And none by the defense, Your Honor.
And have I complied with the court?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be April 8th, 2026, 9 a.m. That's before me. And also 25 FB 1343 is word dismissed.